Good.
Hello and welcome to our webcast for December 8, 2017. My name is Christian Debré and this is Amy Asbrook, the director of Toujours Vivant, Not Dead Yet.
Hello.
Toujours Vivant, we have with us Taylor Ayat, who is our director of communication and
policy analyst.
Policy analyst, sorry. Okay. Okay. Toujours Vivant is Not Dead Yet is a non-religious organization by and for people with disabilities and our allies. Our goal is to inform, unify, and give voice to the disability rights opposition to assisted suicide, euthanasia, and other ending of life practices that discriminate against people with disability. Today's topics, we have two. The first one is review of Canadian disability legislation, Nova Scotia. The second one is legal assisted suicide affecting a response to traditional suicide. Let's be normal suicide or whatever, okay. We try to make it that suicide who is not assisted suicide.
Right.
Okay, alors, Amy Asbrook will talk to sorry.
Welcome back to our review of the accessibility legislation across Canada. This week we're exploring Nova Scotia's Accessibility Act, which was passed in April of this year. As in other provinces, the Act aims to, quote, prevent and remove barriers that disable people by creating standards in a few major areas. The Nova Scotia Act focuses on goods and services, information and communication, transportation and its infrastructure, employment, the built environment, education, and prescribed activities or undertakings.
Okay.
And it doesn't define those.
As far as I understand, it tries to give some tools to people with disability to fit in the society. It doesn't try to give them rights to fight for or to be more independent.
Right. It's very general in talking about preventing and removing barriers, and it doesn't talk about dealing with discrimination. So that's a problem. And it's so general that whatever the specifics are going to be developed by administrative procedures, which is not something that people have a lot of input into. So that's another problem. More specific
input or knowledge.
I'm sorry?
Sorry. Input or knowledge. The process is a big secret.
Right. Exactly. Exactly. The process is a big secret. More specific information about the accessibility standards in each of these areas is not yet available online. We don't know, for example, whether all new city buses will be required to have ramps, or, for example, what the standard of education is going to be. Will it be the least restrictive environment?
Or just a ramp for one
school? Yeah, or just, you know, removing some architectural barriers. We don't know what the standard is going to be.
If it will be very narrow or very wide, nobody knows.
The requirements are part of a strategy that will officially begin next year and lead to, quote, an accessible Nova Scotia by 2030, unquote. These disability rights, I'm sorry?
Sorry, I keep cutting you off. What does that mean? We have these strategies that are supposed to lead to accessible province X, but do very little that way.
Right. Exactly. Yep. These disability rights statutes are very discouraging insofar as they essentially move lawmaking from the open forum of the Parliament to administrative departments under a procedure which is neither democratic nor transparent. So
yeah, okay. They move from the government, which is elected, to a committee who will be named and not transparent at all.
Right.
Okay.
Right. And there won't be hearings, there won't be public process of decision making about what those standards are.
And information may be
Hidden, yeah.
hidden.
Yep. Yeah, information is not going to be easily available about what they're deciding. For example, we've been waiting for the federal government, this is on a different subject, but we've been waiting for the federal government to issue draft regulations on the medical aid in dying program for a year and a half, and they haven't done it.
Yeah, and it's very important to the managing of this law.
Right.
So if you doesn't have any tool to measure, you could not do anything about if it's right or if it's wrong.
Right. So we have to go to this one website every week and see if they've issued the regulations yet. And, you know, we'll circulate the word as soon as we get it, but that doesn't mean everybody's going to know. In the legislation, disability is defined as a physical, mental, intellectual, learning, or sensory impairment, including an episodic disability that, in interaction with a barrier, hinders an individual's full and effective participation in society. And again, they're using the term barriers, but the problem is that that doesn't necessarily bring in the idea of attitudinal discrimination, the attitude that people with disabilities are not as qualified as other people. So we'll see how that works out in reality. Mm. 2 organizations have been founded to guide the Accessibility Act's implementation. The Accessibility Advisory Board will set priorities for the Act, including the design of standards, and evaluate whether measures currently in place are effective. Members will be appointed by the province's Lieutenant Governor, currently Arthur LeBlanc.
Okay, he's a very nice guy, but this position doesn't have any power. It's just the representative of the Queen,
right.
And his function is mainly to do some, I don't know, ceremonial thing, you know.
Yeah.
This is the main use of this guy.
Right, exactly. He's not an elected official. He's not accountable to anybody. And so whatever decisions he makes are really not, nobody has any redress.
No.
Nobody can complain. The Accessibility Directorate will be responsible for conducting research, making recommendations, and reviewing policies and practices. The Directorate is appointed by the Minister of Justice, currently Diana Whelan. So at least that's more functional part of the administration. But again, this is the administration. This isn't the Parliament making decisions in open session about what kind of standards are going to be used in the law. This is, you know, the administration making secret decisions with some stakeholders. The Act is enforced by the Compliance Director through inspection of businesses, orders to remedy non-compliance, or fines up to $250,000. Unlike other provinces where the fine goes into the general fund, the money must be used for the purpose of accessibility initiatives, including public education and awareness. So that's a good thing. Instead of when states and governments deinstitutionalize people, they kind of saw it as, hey, free money. We're closing down the institutions. We have free money. We can spend it on whatever we want. The programs that people needed to support themselves in the community never happened.
Yeah.
So at least this is going to go directly toward accessibility, we hope.
We hope.
Right.
How much will awareness do, though?
Right, exactly. Right. It's going to be about awareness. It's not going to be about ending discrimination.
Right.
The director will keep a database of all complaints of non-compliance, inspector visits, orders issued, director review notices of administrative penalties and appeals. However, that information is not available to the public. It is only used to prepare an annual summary for the Justice Minister.
So it will be difficult to get it,
Right.
and we will be lucky if a functionary or
Functionary.
Functionary give us a copy.
Yeah, there's no guarantee that that information will end up online. It'll be part of the statistics of the report, but as we've seen with assisted suicide laws, the statistics in the reports don't show the whole picture of what's going on in a given jurisdiction. The Minister of Justice will publish annual reports about their own activity under the Act. All public sector organizations, municipalities, universities, and government departments also have to create accessibility plans and make them available to the public. These plans must include past, present, and future actions to identify, remove, and prevent barriers, and how the agency will evaluate the accessibility of its policies, programs, practices, and services, and their related bylaws. So that's fairly standard for government agencies, that they have to determine where they need to make improvements for accessibility and how they're going to go about doing that. When designing a plan, the organization must consult people with disabilities as well as disability groups. They must also establish accessibility advisory committees, where at least half of the committee members are people with disabilities or representatives from disability groups. The plan must be updated every 3 years. So when you're talking about representatives of disability groups, if the disability group is actually like a non-disabled or people running a long-term care facility, that's not going to be disabled people.
No.
So
it removed the majority to somebody else than handicapped people.
Right. It makes it so that there may not be a majority.
Because it will be half who are not disabled people or not related, and a part of the other 50% will be disabled people. So just a part.
Right.
So the majority will not be handicapped people.
Right. And as we've talked about before, oftentimes the interests of parents are not the same as disabled people. There's a controversy now. There's a new book by a parent of an autistic child that is very nasty about the child. And the autism community is up in arms to create a boycott of this book, which, you know, all the non-disabled people who read the book, oh, you know, poor lady, you know, this poor lady has such a terrible child. Whereas the autistic people are saying, you know, she's not very sympathetic. And this is an example of the parents' interests being different from the child's.
Completely.
And the non-disabled person's interest being different from the disabled person's, and that can cause problems when non-disabled people are representing the interests of disabled people on committees. Private businesses need to keep records of what they have done to comply with the legislation. 4 years after the Accessibility Act comes into force in 2021, the effectiveness of the Act and its standards must be reviewed. After that, reviews will take place every 5 years. I don't know if they're going to have all their standards in place by 4 years from now, since they haven't started, and it's almost a year since it's 6 months since the law was passed. The Accessibility Act, go ahead.
They're still allowing for continued design of standards, right? Like in Ontario, they're still making a lot of pressure to put the education one in place right now.
Right, exactly. Yeah, they're taking their sweet time about it.
Yeah.
The Accessibility Act isn't the only disability-related law getting a lot of attention in Nova Scotia. In October, the controversial Adult Capacity and Decision-Making Act came into effect. The original version of this law allowed a court-appointed guardian to automatically control the financial, healthcare, and personal decisions of a person who is declared incompetent. Although this proposal was designed with good intentions, it violated the rights and freedoms of people with intellectual disabilities. And there was quite an outcry because, you know, they really just said, well, if there's a question, put in a guardian and they'll sort it out, which is kind of crappy. Many disability rights organizations and advocates, including the Canadian Association for Community Living, asked legislators to allow for supported decision-making instead of putting guardians in place right away. However, all of the proposals were rejected. The law was eventually changed to require the least restrictive and least intrusive form of representative decision-making. And this includes recognizing that the person may have decision-making capacity in some areas, but not others, requiring regular reviews of guardianship orders, and allowing for supported decision-making where possible.
Just allowed,
right.
Not
mandating.
Mandating, which is not exactly
right.
Very less powerful. And most of the time, it will not be that way because it costs money.
Right. Well, not so much that it costs money, but it leaves it up to the judge's discretion, and the judges have the same biases about disabled people everybody else does.
I agree.
So they're going to say, well, you know, you can't make decisions, so.
No. And especially if your disability is intellectual, it often takes people who know you well and have your interests in mind. A judge wouldn't be either of those things.
Right, exactly. And, you know, you have to have an advocate speaking on your behalf who does have your interests in mind. And if there is somebody in your family who is speaking on the opposite side of that, who says that your interests are something else, then that's going to create a lot of problems. And unfortunately, judges generally go with the family member rather than the external advocate.
Yeah.
Because disability advocates had to fight for the law to be changed, many Nova Scotians are now aware of the disadvantages of guardianship and the need for Nova Scotians with disabilities to have as much choice as possible. And, you know, in guardianship situations, that's really true. People need to have choice over what's going on with them, but it's so it's a new idea, and a lot of people have a hard time accepting that. So, okay, our second topic is legal assisted suicide is affecting responses to traditional suicide attempts, and traditional is just ordinary suicide attempts without physician assistance. For a long time, advocates against assisted suicide have wondered about the effect it would have on society's response to suicide attempts that were not medically assisted. We recently discovered a document released by the College of Physicians of Quebec in March 2016 that explored suicide attempts as an expression of refusal of medical treatment. And the paper, unfortunately, is only available in French, but we'll give you some idea of what it says.
And this report was sent without any press conference,
right.
without any knowledge of everybody, just released somewhere, probably a Friday afternoon, something.
Right.
Because we miss it,
right.
and we found it recently.
Right, we missed it. Somebody else wrote an article that mentioned it, so we picked it up and are giving it more information.
It was not really, if it is public, but not publicized, which is not the same either.
It was written after the college learned that some people who attempted to end their lives by drug overdose in the fall of 2015 were not given treatment that might have enabled them to survive. The college discusses the need for physicians to obtain the consent of a patient before starting treatment, as noted in the Civil Code of Quebec and the Act respecting health services and social services. The law on end-of-life care also allows for the use of advance directives, documents specifying the wishes of a person who has become incompetent. So those are the laws that exist now, and the laws that exist basically suggest treatment when somebody is, getting the permission for treatment, except if there's an emergency. And then in the emergency, you don't have to get permission. Since the goal of medical professionals is usually to save a person's life, and a suicide attempt is usually an emergency, doctors are unsure of their duties towards an unconscious patient who has attempted suicide. The Civil Code and the Code of Ethics of Physicians say that consent to care is not always required in an emergency. So obviously, they can provide care, and yes, this was to provide guidance as to whether they should.
And normally they must. Not only can, they must provide in an emergency situation. They must protect the life.
Right, exactly.
This is their target as medical professionals.
This is their job.
Yeah.
The authors ultimately conclude that suicide attempts are not the same as refusing medical treatment. Suicide attempts are considered emergencies, and a person's suicidal state is not reason enough to deny the medical treatment.
Yeah, because most suicide are just a cry for help.
Right, right. The doctor must have proof that a person doesn't want to receive certain medical interventions. For example, a do not resuscitate order or other advance directive. So if the person comes into the hospital, even if they have a disability, if they don't have a DNR and they don't have an advance directive refusing treatment, then they need to be treated if they've attempted suicide. The only form of suicide that should be respected by doctors, quote unquote, is one in which they assist directly. Euthanasia requested and approved according to the requirements of Bill 52 that came into effect in December of 2015. Only circumstance. But in this situation, it's weird because what the promoters of assisted suicide are doing is they're trying to get suicide prevention organizations to make a distinction between assisted suicide and saying that that's not really suicide and other suicides. And
which is not the same.
Right.
It is the same.
Right, it is.
It is the same.
Right.
A suicide is a suicide, whatever the way it is.
Right, right, exactly. And, people who, like Herbert Hendon, who is a pioneer in the area of suicidology, the study of suicide, has said this is the same issue. People are presenting the same concerns, the same issues. But the promoters of euthanasia are trying to change, distort reality by getting these suicide prevention groups to say that there are different kinds of suicide. And it's that sort of advocacy that's creating the confusion when doctors see a person with a disability who's attempted suicide. Hey, wait a minute, should we help this person to die? Because, maybe they were requesting suicide. No. Okay. Yeah.
No. How clear do we have to make this for you? Suicide is suicide. That is that.
They're to win or they're all in the middle.
Right. There's an interesting distinction, especially considering a question that is asked toward the end of the paper. How can suicide be called a refusal of treatment when that so-called choice is driven by a psychiatric condition that may affect someone's decision-making abilities, physical pain, or family conflicts and other social issues.
Something is not correct.
Right. So they're acknowledging that those are the factors that lead people to commit suicide. And we're saying, yes, those are the same factors that lead people to request assisted suicide.
Yes, it's what we said, and it's what this is the reason what it is not logical. It's just the opposite.
Right, exactly. If the college recognizes that suicidal feelings and actions can be brought on by any of these factors, why does the approval of a doctor suddenly make suicide by euthanasia acceptable? Because it's clear, one of the things that's a little unclear in their report is they say, you know, assisted suicide is not legal in Quebec, which is true because it's euthanasia. Quebec has a very protective and paternalistic law. You can only have euthanasia. You can't have assisted suicide. Also, the process described by the college for determining whether the person has capacity or is subject to other influences is more thorough in this case than required by the euthanasia law. Why a different process for those who attempt suicide as opposed to those who apply for euthanasia? Well,
there's no reason.
Well, there is a reason. The reason is discrimination.
Yeah. Try to explain it without this argument.
Right.
And I can see them saying, oh, the person who applied to die with a doctor's help, the written request that we can look at. With another suicide attempt, they see the cry for help more easily, which is ridiculous.
Yeah.
Okay.
Well, I mean, to me, the application is a cry for help, but, you know, whatever.
You're right, it is.
Yeah. And that, you know, making that distinction, again, this is where the advocates of assisted suicide are trying to torture reality into some odd, twisted shape.
Yeah.
The college fails to acknowledge the inconsistencies of the euthanasia law, medical ethics, and suicide prevention policies. It's very frustrating to see organizations that should be consistent in their suicide prevention efforts buying into this line of thinking.
And we have to think about the restriction of the Carter case. Carter case was very clear.
Right.
You have to protect those
vulnerable people,
vulnerable people, which are not made in any law in this country.
Right, exactly. The protections are not working. We know in Quebec that people who are not eligible have died, and that is, you know, against that goes against the Carter decision.
And it is an homicide, and nobody any inquiry about it.
Yeah.
But it's still homicide.
Yeah.
Because we have to remember that the right to kill people came by the side door, which is we create a little notch inside
exception to the homicide law.
Of the homicide law.
Yeah.
Okay. And if you go outside of this little notch, you are a criminal.
Right. Did you have anything you wanted to add, Taylor?
I think we've already covered it.
Okay, sounds good. Okay, so if you want more information about the topics that we discuss here, you can go to our Facebook page at facebook.com/toujourvivant, not dead yet. You can also visit our website at tvndy.ca, and there if you don't use Facebook, you'll see our Facebook feed on our website, so you can get it all there. Also, you can send us an email at info@tv-ndy.ca, or you can follow us on Twitter @TVNDY. Thanks to Taylor and to Christian for helping out.
Thank you, Amy.
And thanks to you for being there. We'll see you next time.
See you next time.
Bye.
Take care. Bye.